Good afternoon, and thanks for joining us today. Today, my topic is the top four tactics you must know to protect your most valuable assets. And go to the next slide here. My name is Russell Berger. I'm a labor and employment attorney at the law firm of Offit Kerman. And one of the things that I really focus on when I represent business clients is helping you, the business owner or the operator, make good, sound decisions to protect your assets and to grow your business. And I think sometimes people think of lawyers as folks that are going to hit the brakes and are going to slow you down and are going to tell you what you can't do with your business. But really, there is some component to putting some guardrails up and being conscious of the law and not running afoul of things. But the law is also an opportunity and a tool to help you protect your business. It's not all anti-business. It's a tool that can be used for your benefit. So what we really want to cover today is four general categories, four general topics as to how you, business owner of a growing business, can utilize the law to help your growth, help propel your growth, help protect you as you grow. So, with that said, we'll just dive right into the first big issue here, and that issue is intellectual property. So, the first thing I want to touch on with respect to intellectual property is it's important that you recognize what is intellectual property and what your rights are. So, it could be as simple as your logo. If you haven't had it trademarked, someone come along and take it. Someone come along and take your name. So you want to be careful about those things. And that's just kind of like the entry level. As you go up the level of sophistication with respect to intellectual property, you get into things like patents and copyrights, as well as trade secrets. And patents and copyrights are things that are protected, can be protected by the law, and those patents would involve things like innovations, developments, you could have a patent for a new method, and copyrights are intellectual property protections for things that are written. I also have on the slide here trade secrets. What trade secrets are, they may not rise to the level of trademarks, patents, or copyrights, things that the federal government would issue protections for, but they're still pretty important. And they're not things that you want in the public space. So, for example, and this may touch on a couple of these different categories, is we all know about Coca-Cola and their secret recipe and how that's, among other things, a trade secret. So the handful of people that know what that recipe is are almost certainly bound and protected by all sorts of agreements that would require them to keep that information confidential. So just that example there leads me to 2 points and 2 ways you can protect your intellectual property, even if you don't have the billion-dollar formula to Coca-Cola. The first being, you want to keep your sensitive information to as small a circle as possible. Obviously, you have things, and we'll touch on this a little bit later in the presentation, but you have things like customer lists. That's proprietary, but more people are going to know about it because you have a sales team, or you have people trying to make sales, or you have people working on the product for those customers. So you can only keep that circle so tight, but I think the general advice is to keep the circle as tight as you can, particularly when it comes to when you've got the recipe for the secret sauce. In addition, you also want to protect yourself. And that's protecting yourself with your employees. That's protecting yourself with your customers. If you use vendors, it's protecting yourself with them as well. So when you have agreements with employees, with customers, with vendors, you should include some intellectual property protection language in those agreements. That's an important thing to keep in mind, because while we often think about it in terms of our employees, who's inside the house, who we want to limit and protect, we don't necessarily think about it as much with external third parties, but that's still a protection that I think is important because you don't want to sell your product and have someone else be able to cut you out of the loop going forward. Instead, what you can do with third parties is you can enter into licenses. So that's not something that's probably a little bit more detailed and nuanced than we have time to go into in this presentation. But the short version is that when you have intellectual property rights, they're just like any other right. You can sell them, you can rent them, you can do all sorts of different things with them. And so a license is essentially renting it to someone. Say, hey, this is still my intellectual property. I still own this, but I'm going to permit you to use it, and you're going to pay me something for that usage. So that's the quick version of what a license agreement would be. The other important thing that you want to do is you want to monitor your intellectual property, and you want to monitor how it's being used, or if it's being used by others out there in the world. So there's certain services that will allow you to track trademark usage. That might be something, particularly as you grow, that you become more concerned about. And then lastly here, litigation is an option if you get to a point where there's a dispute. Ideally, if you're going into litigation, you've put agreements in place, you've done all these things to protect yourself. You've made clear that your trade secrets are secretive and you've kept them under lock and key. You've done the things to show that you actually do think it's secretive. And a footnote to that point is if you have things that are trade secrets, but you leave them laying around so anyone walking through the office could see them, a court's going to be a little skeptical as to whether or not they're really trade secrets. So things that are secretive, things that are proprietary, you really should keep them under lock and key. Whatever that means in a digital age. But if you do all those things, you put the right agreements in place, and you need to enforce it, you're at least, if you get to litigation, you're at least well prepared, to be able to enforce, and you've got all your ducks in a row at that point. All right, so the second topic I really want to hit on today, and this is more in my sweet spot as an employment lawyer. I draft these policies and I work with these policies and try to help employers enforce these policies all the time, are employment policies and practices. And, there's a lot more than three things we could talk about in this realm. But I think these are probably the three biggest issues that I see on a day-to-day basis. The first being, it's really important that you classify workers properly, and particularly in a startup or a growing business, what we see a lot is workers being classified as independent contractors and not employees. So, we'll pay them a 1099, we won't pay them by W-2. And what we see, the reason that happens is because it's cheaper to pay someone 1099. You don't have to worry about, if you have benefits, you don't have to worry about putting them on benefits. If they're 1099, you're not paying payroll tax, you're not paying unemployment, you're not necessarily paying for workers' comp insurance for them. So there's a lot of reasons, financial reasons, why it's advantageous for a worker to be an independent contractor and not an employee. As you might guess, though, there's a lot of advantages for workers to be classified as employees. It's the converse of all those things. They get these benefits, they're protected. And they don't have to pay the self-employment tax because the employer is going to pay their half of the payroll tax. So the important thing to keep in mind here for any business is it's not your choice whether someone is an employee or an independent contractor. It's your choice as to how you define the nature of that relationship, as to how much control you exert over the worker. You can change the facts, you can change the relationship, but ultimately the question of whether a worker is an employee or an independent contractor is going to be a legal determination. So as you can see on the slide here, it's a legal question, it's not a choice. The choice is in how you structure the relationship. So, one way to think about this is if you really want independent contractors, but you're concerned you're in a gray area, which is often the case, you can start to set up you can draft an independent contractor agreement. you can work to define the relationship in a way that gives you a better argument that the person's actually an independent contractor. So being aware of the independent contractor employee test will help you structure your workforce in a way that makes the most sense to you. Now, that being said, and I'll say this in general terms and it certainly applies here, pretty much, I know I said earlier that law, you can use the law to your advantage, and I still think that's the case even in employment. But these laws certainly have a thumb on the scale in favor of the individual worker, the employee. They're not designed to benefit the business owner. So misclassification issues generally, you got to start with the presumption that the worker is going to be classified as an employee, and you try to create a system that takes them out of that, assuming that's actually right for your business. If you have someone who works for you full time and you tell them when and where to work and how to do it, they're going to be an employee. There's not a whole lot we can do to change that. But that's still important to know because you want to make sure you get out in front. And if they are an employee, then there's things you can do. You can exert more control. You can lean into that, and you can get some benefits in some other places as well. So one other note on that is that there's a whole bunch of different laws I mentioned. There's a few I didn't mention, the wage payment laws, the IRS, the unemployment, workers' comp. There's all different. Every one of those laws is a different test for employee versus independent contractor. And I would say that in general, they all kind of have a slant towards employee classification, and they all largely rely on the amount of control exerted by the business in making that determination. But they're all multi-factor tests. There's a whole bunch that goes into this. So, if you're sitting there thinking, hey, I've got people that work for me full time and I'm 1099ing them, you should certainly look at that more closely to see if what you're doing is is compliant with the law or not, because there's a pretty high risk in that sense. So another thing that I think is really important for you to know as you hire and grow your workforce is you got to know what laws apply to you, and you got to know what to do when you get complaints under those laws. So there's a whole bunch of federal laws, there are state laws, there are county laws that are analogous to these laws. So depending on where you are, there's different employee count thresholds. But just looking at the federal level to kind of keep it simple for the moment, Title VII is the law that protects against discrimination and harassment based on a number of different protected classifications, which are based on inalienable traits that people have. The ADA is the anti-disability or the anti-discrimination related to disability law, and requires you to engage in an interactive process and make reasonable accommodations to workers that have a disability. The ADEA is the Age Discrimination in Employment Act. It means you can't discriminate against people who are over a certain age, and for purposes of this law, that age is 40. So as I've gotten older and gotten more experience as a lawyer, 40 doesn't seem so old to me anymore, but be that as it may, that's the cutoff for age discrimination. Over 40, you could be discriminated against because you're too old. And the FMLA, which is not going to apply until you hit 50 employees, but it's the unpaid leave for certain medical reasons, whether it's the employee directly or their family members. I leave that on there just to note that if you get over 50 employees, you should certainly have that on your radar, and you should certainly have a policy around that. But in certain jurisdictions, not necessarily in Maryland, there are baby FMLAs with lower thresholds. So, one thing we ought to all be conscious of as we hire new employees in a remote world where we can pick the best employee regardless of where they live is that we're stepping into different states' versions of employment laws. So, as the saying goes, we have 50 little labs of democracy in this country. And the upshot of that for employers is you got 50 different state versions of these laws you have to deal with, and they're not 100% aligned. So you ought to know what you're stepping into when you hire someone in the new state. Um, Importantly, though, with respect to this, and this is usually a pretty straightforward thing to include in a handbook, which if you have a handful of employees, you ought to have an employee handbook. Um, is the process and the procedure by which you're going to deal with complaints. So if someone feels like they've been discriminated against or harassed in the workplace, or they have a disability and they need to request an accommodation, I think it's important for employers to provide a roadmap uh, to their employees so that they know how to initiate that process. And by doing so, there's also going to be a roadmap for the employer as to how to handle that process. And certainly, I get calls to help on the back end, to help steer people through these methods. But it's something that it's very helpful to have it laid out so everyone kind of knows what that roadmap is. And when you have certain issues come up, you can call, you can get guidance on it, and that's an important thing to know as well. So while you have the roadmap, you have a good starting point. The handbook. No lawyer is going to draft a handbook for you that's saying the wrong thing in this respect. It's all going to point you in the right direction. It's all going to be compliant. But in practice, new situations come up. Know that that's a good time to ask for help, so you don't get too far afield from what's compliant. And then the last big employment policy I want to mention is planning for terminations. And the simplest way I would put this is that if you have the example that I have from my practice all the time is I get calls from clients and say, we want to fire this person, or we fired this person. They're complaining about discrimination. And the client will go on to tell me, and this was such a lousy, terrible employee. And I'll say, okay, great. Well, that's a good basis for termination, and that's something we can certainly feature prominently in the defense. Send me all the performance reviews and the PIPs, the performance improvement plans that you've done documenting all this. And then the call goes quiet for 30 seconds, and because they haven't been done. So it's really, really important that you document this along the way, because you don't know how things are going to end up. But I would say more importantly, the expression from my standpoint is that managing up and managing out look the same. So, if you're managing your workforce and you want them to improve, you should be doing performance reviews. You should be using PIPs when appropriate. You should be pushing people forward and managing their performance. And if you do that, and it doesn't work, you're set up to terminate, because you've shown that you've documented the poor performance, and you're not as vulnerable to a claim that you didn't, that your basis is discriminatory or retaliatory or otherwise unlawful. The last thing I want to note on this is when you do have termination meetings with employees, the idea is to be empathetic. You're telling someone they've lost their job. That's a lousy message to communicate, but to be direct, to the point, get in, get out, and not have a debate about it. You've already made the decision. You don't need to debate the decision with the employee. You're informing them of the decision. You're not having a discourse regarding that. So, third big topic I want to talk about is employment agreements. Employment agreements can do a lot, and you can use them in a lot of different ways, in a lot of different contexts, and you can get real fancy, and you can have employment for a specified term, and you can have complicated bonuses and incentive structures embedded in them. But the primary reason to have employment agreements, whether you call it an employment agreement or whether you call it some sort of restrictive covenant agreement, is, and this ties back to what we talked about with respect to intellectual property, is to protect your stuff. And whether it's federally protected intellectual property, whether it's a customer list, whether it's proprietary information, you want to have an agreement that protects your stuff as much as you can, because that's really a key to your growth. If your competitors had what you had, how would that impact your growth? It'd be bad for it, obviously. So, having an ability to protect yourself and using agreements to do so with your employees is really important. So as you can see here, I've bullet pointed a couple of the provisions that I think would generally go in any type of employment or restrictive covenant agreement. The first being non-disclosures. So that's really confidentiality. So whether it's intellectual property, and you can have an agreement that also assigns any intellectual property that's created during the employment to you as the employer, and I'd recommend doing that as well. But whether it's an intellectual property or um, it's proprietary information, it's customer list, you can put an agreement in, or you can put a provision in an agreement that says, the employee won't do anything with that. They won't use it for anybody else's benefit. That's an important thing to have. It's a valuable thing to have. Similarly, we've also got non-compete provisions and non-solicitation provisions. And a non-compete, at least here in Maryland now, is getting progressively harder to enforce. There is now a wage threshold. So if a worker earns less than $15 an hour or less than $31,500 per year if they're salaried, they're not eligible to be subjected to a non-compete. It just won't be, it'll be invalid if you have them sign a non-compete. However, non-competes are still valid for higher earning individuals. But I'm not the biggest fan of non-competes. I think they have their value and I think they have their place. But a non-compete basically says you can't work at all, and you can't work in this space. Lawyers can't be, as a matter of law, cannot be subjected to non-competes because we're so important to society that it would be such a wrong that you couldn't hire me to represent you. That we had to write it into the law ourselves that we couldn't be bound by non-competes, which really shows you the power of being the people that actually write the law. But if I were using a law firm as an example, a non-compete would say, well, you can't practice law in this geographic area for this amount of time, and it all has to be reasonable for it to be enforceable. Judges don't like that generally because I don't think they really want to tell people they can't work. And it's a hard sell. So that reasonableness test when it comes to non-competes is probably a little more slanted towards the individual employee who just wants to go out and work. However, that's why if you use whether you use a non-compete or not, I would recommend a non-solicitation provision. And what non-solicitation, and sometimes that kind of veers into really a very narrow form of a non-compete, does, it says you can't solicit or work with the customers that you worked with while you were here, or the prospects that you were prospecting while you were here. So it becomes a narrower, and narrower also is probably synonymous with more enforceable way to protect yourself. So, to use my analogy to the practice of law, what my firm would be saying to me in that scenario would be, you can go work anywhere else you want, but you can't take any of the clients with you when you leave. And if there's anybody you were pitching before you left, they stay here too. And so I kind of like to think of it as you can't, we don't care if you shop in the same grocery store as us, just don't take any food out of my cart. And that's really what the non-solicit is. And there are strategic reasons to pair that with a non-compete, to not have a non-compete at all. There's different ways to think about that. But ultimately, I think that's a conversation that if you have stuff that you think needs to be protected and you're worried about building your customer list, you should certainly have these types of restrictive governance in some form or fashion in place. I mean, because ultimately, you think about it, if you're a small business and you're growing and you've got a salesperson or a key employee that's really built up relationships with a bunch of your clients, if that person leaves and the clients can follow that person, you're going to be in trouble. So make sure you protect yourself. The last type of employment agreement that I wanted to mention briefly is our severance agreements. And severance agreements are things that are provided at termination, and you pay some amount of money. Generally it's measured in weeks of wages for a full release. And if you don't have restrictive covenants in place already, you could try to stick them into a severance agreement as well. It's a way to get confidentiality. It's a way to get non-disparagement. So you don't want anyone saying anything bad about you after they've left. You can kind of buy your peace through a severance agreement. All right, and the last topic I wanted to talk about today is insurance. Um, Insurance is certainly worth having. Nobody gets excited about paying for insurance. There's no immediate return. You write the check and you've got a policy, and that's fine, but it's not really exciting. Um, but if you find yourself in a situation where you need to make a claim and you're protected, and you're being sued for something, or you suffer some kind of damage that would otherwise knock you out of business, you're going to be really appreciative of the fact that you do have some insurance in place and you do have some protection backing you up. I mean, you're working. I know probably everyone here is working extremely hard to build and grow a business. It's really important to have some protection around that, because you don't want your efforts to be undone by uh, one mistake or something that's not even a mistake, that's just bad fortune. So, you want to make sure that you're protected, and you want to make sure you know what you have. Um, you should certainly do a periodic review of your insurance policies to make sure that you have in place the right things for what your business is, what your business is going to be. And we say the same thing in the employment context all the time. Just because something was a good policy for you a year or two ago, you're growing, now it's different. You might need a different policy. It might not fit the same way. You might need a different type of insurance or more insurance, or the number might need to go up. So that's something that is important to keep in mind and important to track. Certainly a conversation you should have with your insurance broker, but it's also a conversation you can have with your legal counsel as well, because certainly we're used to gauging the risk of of things that may not be compliant with the law, and certainly of assessing and evaluating insurance policies in that context. One other note here, and it's not so much specific to the insurance policy piece of this, but it's and I understand this is a little bit of a challenge when you're still kind of in the extreme growth phase of a business. But if you can take the cash out of the business and put it somewhere else, it's safer. So when you get to that stage, you want to think about different ways to do it. There are all sorts of nuanced corporate law mechanisms by which you can transfer cash to yourself and loan money back to the business, and there's different ways to structure those things. So you want to keep that in mind. So I would say that it doesn't. While the advice is, from a legal standpoint, you're safer if the cash isn't tied up in the business. The practical point is, if you can put the cash in your name but loan it back to the business, and still use it to drive the growth of the business while still protecting yourself, and that's even better. And fortunately, there are mechanisms and processes in the law. Some of you may have heard of debentures, that allow you to be able to do things like that. So those are certainly conversations, things you want to be thinking about, particularly as the cash starts to come in. And kind of along those same lines is how you use corporate entities to best protect yourself. And we could go on forever about all the nuance that goes into that, but sometimes it makes sense to have a holding company and to have multiple different entities and kind of silo. If you have different operations, it oftentimes makes sense to silo your risk. So you have different entities for different operations, and if one of those entities gets sued, it's easier to contain it to one entity if you've got them siloed in that manner. So that's something else to keep in mind. And again, these are all topics that I think really help to inform the way you grow. And these are things that you should be thinking about and planning for as your company grows, as you take steps forward. If nothing else, if I leave you with nothing else today, the point really is to think about these things and to revisit these types of questions. And in a session like this, we can't answer everything. We certainly can't customize a plan for each of you. But what we can do is raise these as topics that you should be thinking about. And I know as a business grows, one of the big issues is you don't know what you don't know, And hopefully today I've given you a little bit more guidance around that point. So if there's anything else I can do to help you, there's my contact info on the screen. Thank you very much.